Welcome, everyone. I'm Elizabeth Luevano, the immigration attorney that's managing our Dallas office with the law offices of Sabrina Lee. I specialize in removal defense, family-based immigration, humanitarian relief, and some immigration appeals. And today we're joined by a very special guest, Dr. Felip from the
Uh,
Alexandre Law Firm. And he's here to help us unpack all of the latest developments of U.S. immigration enforcement. It's great to have you here. Could you please introduce yourself to our viewers?
it's awesome to be here. Thank you so much, Elizabeth and offices of Sabrina Lee. My name is Felip Alexandre. I've been an immigration attorney for 13 years now. I've seen not everything because there's always something new, especially at least recently, but we've handled pretty much most types of immigration situations. And this is an especially, I don't want to use the word exciting, but it's a very important time for us to have immigration warriors on the front line defending our clients. So I'm very happy to be here and doing this collab with you guys.
Yes, that's so true. So today, what I wanted to do is just take a deep dive into one of the toughest areas that I think we're experiencing right now in the immigration field, and that is detention. What we're seeing for detention, especially mandatory detention or bond ineligibility for people who entered without inspection, and how DHS and ICE have started to expand that detention authority, increasing their detention efforts, not only for people, apprehended at the border, but also people caught inside the states, and how they have shifted the way that they're now treating people that have these encounters with them, all of that ongoing litigation, the new case law that's affecting it. So I want to explore how it's evolving, what this means for people who are watching, and what tools and strategies we can still use as practitioners to seek their release. All right. So then I guess let's start with the big picture. We can talk about how has ICE and their use of detention changed in 2025? What are the new trends we're seeing for people who have entered without inspection?
Thank you for that question, Elizabeth. So we've seen that ICE is really leaning heavily on using a section of the law called INA, Immigration Nationality Act, Section 235B. That section technically applies to people considered arriving aliens. These are people who are literally stopped as they're crossing the border, or maybe they're stopped at sea before they reach our shores. But now they're trying to apply this more broadly. So essentially, this puts people in a category of a kind of mandatory detention where the immigration judge doesn't have jurisdiction over bond. And now they're expanding this to people who are found in the United States wherever they're found, and even if they've been here for decades. So they're really, treating these people like they just crossed here yesterday, and they're trying to expand their detention authority.
Yeah, and we've been seeing the same thing, and that's truly what many believe. That's not how this section of the INA was originally intended to work. That's not what the intent was when this was written. But it seems like DHS and ICE are taking advantage now of those different definitions that are found in the statute, even though they've never been interpreted that way, and having it now include anyone who hasn't been formally admitted or have some type of like legal status when they entered.
Exactly. The regulation, 8 CFR 1001.1, it defines arriving alien as someone who is applying for admission. And so there's another section of the law in 235A1 that says that anyone not admitted is an applicant for admission. And so now ICE is trying to use that combination to classify any long-term resident who might have been IWI, who might have entered without inspection. They're classifying everybody as an arriving alien, even if they were picked up hundreds of miles from the border, even if they've been here for much more than 2 years. But unfortunately, ICE is getting help from a very important court, the Board of Immigration Appeals, and we'll certainly talk more about that.
Isn't that the truth? And yes, that change in classification, that's what has now changed the entire sphere, the scope, the playing field that we find ourselves in now as practitioners, because now these people, like you said, they're in mandatory detention under INA 235B without the right to bond, without the right to even have their cases heard before an immigration judge. They've cut their rights off like right at the legs.
Absolutely. And this is very concerning because now when ICE arrests these people who have been here, they're long settled individuals, long-standing members of our communities, parents, workers, people with pending relief before USCIS or even before immigration court, all of a sudden they're classified as arriving aliens. And so if immigration is able to do that, if ICE is able to do that, then they have the power to really detain these people indefinitely without the bond process that we normally expect. And that was usually applied under another section of immigration law called 236. In that section, we just had to prove, look, this person, one, is not a flight risk, and two, they're not a danger to society. And so even if they had come without inspection, if we prove those elements, the immigration judge had jurisdiction, but recent enforcement action and recent jurisprudence and case law from our holy BIA, Board of Immigration Appeals, has made that process a tougher one now.
Yeah, no, you're absolutely right. And then earlier you mentioned, them now changing also the rules about the 2-year residency. So that combined with the expedited removal authority, when someone can't prove the 2 years of residence in the US before their initial encounter with an immigration official, it's a recipe that's, it's causing a lot of confusion, a lot of overreach is what we've been seeing. And having those people here who even have been longer than 2 years treated as people that have recently arrived, it's just something that's kind of causing mayhem.
Exactly. And it's pretty insane because these people who are under expedited removal, if they don't pass a credible fear interview, they might never get to see a judge. Essentially, what a credible fear interview is when you're detained, they're going to ask you if you have fear of returning to your country. It's not enough to say, oh, my country is dangerous, or, I had a bad business dispute there. You really have to have a reason that would qualify under asylum law. And so if the immigration officer doing your credible fear interview decides that you don't pass, they can remove you without you ever seeing a judge. And so that's essentially detention without judicial oversight. And they're trying to expand that. And that's how important it is for us immigration practitioners to push back more than ever.
I agree. The importance right now, it's so critical because we've seen now that the scale that people are being detained indefinitely, basically, and without judicial review, it's truly staggering. I know that Politico reported just last month in September that ICE is now maintaining about 46,000 detention beds, and that's per day. That's the highest level that we've seen even pre-pandemic. And we've seen that all of these detentions are being justified under the border enforcement continuity and having these processes now be interpreted a different way.
And unfortunately, somebody's making a lot of money because we know that this is private detention and some companies are profiting greatly from this. And it doesn't end there. Unfortunately, even EOIR, which is our immigration courts, they released a memo reinforcing this by limiting the immigration judge's authority when DHS claims that 235B applies. So now immigration judges who want to hold bond hearings are being told that their jurisdiction doesn't extend to those cases. And unfortunately, judges are losing their jobs by the dozens. And so, a lot of them are hesitant, to really challenge this.
100%. And we have seen that chilling effect that you were talking about with judges losing jobs. Judges don't want to overstep, and they don't want to say, I have jurisdiction when there's this case from the BIA that strips them of that jurisdiction. And then we've also been seeing a chilling effect on practitioners where if they see this case that says this person is not eligible, the judge does not have jurisdiction, they're not filing. And so we're seeing all of these detainees that are left in kind of a legal limbo.
So, Elizabeth, we've been talking about all the bad news, but there is pushback and there's a fight. So let's talk strategy. What can attorneys do to fight for the release of their clients, or at least push back on this interpretation?
And that's such a great question, right? Let's focus on the positives, things that we can do, things that we can change. So I would say the first step is always going to be to challenge the classification. Just because DHS classifies someone under a certain rule or a certain section of the INA doesn't make it so. So if your client was apprehended at the border, you can still try file for bond, argue that the 235B detention doesn't apply. And then clients also, if you are coming to a practitioner that maybe isn't comfortable filing, you can always contact someone else that might have a little bit more experience in interpreting those classifications.
Absolutely, absolutely. We have to challenge this. And, there is positive case law on the issue. And I say positive case law, some of it has arguably, I don't agree, or been overruled by some of the recent BIA cases. But let's go back. Matter of MS, it wasn't a great decision because it did tell us that, people in, expedited removal, if they pass a credible fear, they couldn't get bond. But it always stood for the proposition that, look, if people came in between ports of entry, they weren't apprehended, and later they, applied for immigration relief, wound up in immigration court. Those people were eligible for bond, and so that case, I believe, is from 2019. So I mean, this has been around, for a lot longer, and even before then, we were getting bonds for people who came in EWI without inspection all the time. I don't understand why that all of a sudden has been overruled. We had recently a matter of Q Lee, which was a different fact pattern, but essentially that tried to undermine matter of MS. And then we had matter of Yahure Hurtado, and that was in I think September of this
Right.
year, which is very recent. And that one pretty much says if you entered IWI, you don't have bond. And that is not based on the law. That is not based on our interpretation of the law. The BIA's previous interpretation of the law, including matter of MS. Why is matter of MS all of a sudden wrong 6 years later, right? And so that's what
Right.
practitioners need to continue fighting against and making a record because there is a fight for people who want to play the long game.
Right. And especially now with Chevron deference no longer being the rule, right? I would say even if the immigration judge refuses to hear the case, let's say that they're abiding by Hurtado, right? If they refuse to hear your case, habeas corpus remains a really good option for people in federal courts. For people that are licensed in federal courts, we've been seeing that habeas filings are important because they are still creating the judicial oversights. Those federal courts are still higher courts, higher than the BIA. So they are still helping us fight the good fight if we're seeing that the way the administration system is no longer working the way it should. Now, I know that success rates are different and courts are treating things differently, but it is, especially in court by court, it is forcing some accountability back into the process.
Sometimes people ask me, what if this was your family member? What would you recommend? And if it was a family member of mine and a judge, because of all these memos and all these judges losing jobs and they're scared, and now with Hurtado and saying they absolutely don't have jurisdiction over cases where somebody came without inspection, I would say do habeas. It is an investment because
Mhm.
usually you're talking about hiring several attorneys. You're hiring the attorney that you trust. Then there has to be a local attorney. So it is an investment, but we are seeing victories across the country from different federal courts who are saying, wait a second, why is the law all of a sudden different because the BIA now decided to issue Hurtado? No, let's look at how it's been the past 30 years. And no, this is a case that fits under Section 236. This person is not a flight risk. They're not a danger to the community, and they should be able to be issued a bond. So, Elizabeth, I love habeas. I think in many cases it might be our only option. There are some things if we take, to habeas, some courts, want more exhaustion, like we tried to, appeal certain things. But, really, federal judges are going to be receptive when you make a solid record. And now they know that there's a precedent that, is having a chilling effect on judges. So I think they will be receptive to these cases.
Yeah, absolutely. I agree with you. I think habeas right now is probably the strongest option. It's the way to go, but it's important to know it's not the only way to go, right? How do you feel about the parole requests directly to ICE seeking discretionary parole under their existing parole authority?
Lately it's been very, very tough. I would say though, that, I mean, it does help you make a record, for, it may be an eventual lawsuit that you're going to file. They're being very hesitant to issue parole lately, but we still do it. We still do it because, a lot of that same material we're going to end up using, for the bond package. So we go ahead and we put it in. I still say put it in, make the record, and you never know, right? I mean, if you have a case that is especially compelling, they still have the authority to grant it. So it is something that you can do, and in the past we've definitely seen it work especially when you can humanize the case.
Agreed, agreed. And I think you're right. We have seen that chilling effect also even in the realm of ICE, right? So ICE might not be as willing to grant these parole requests, but like you said, it's building the record. It's showing that you've exhausted all remedies, that you've done everything you possibly can before you take it to federal court, and that you really have tried to get your client out on bond. So it's so important when we're trying to exhaust these to combine that strong evidence, any kind of medical documentation, family letters, strong ties to the community, proof that you're not going to be a flight risk, proof that you're not a threat, right, to security, and really try to put together a strong packet, get with local orgs, and see what you can do to kind of push back and try to get these paroles, even if it's not likely to be granted.
Exactly. It's not just about the law, it's about how you frame it. And so you're giving DHS, you're giving the government a reason to use their discretion in a way that aligns with its humanitarian mission, which, sometimes they forget. And it's not just an enforcement role. And it's important to also make the record in case this ever ends up in the hands of a superior court.
Right. And then we've also seen a lot of coordinated advocacy becoming powerful in cases that are maybe a little bit more seen in the media or a bit more sympathetic. We've seen attorneys working with congressional offices, clergy, consular officials, the media. It might not always guarantee release, but it might change how far DHS is willing to go in evaluating the case.
Hey, you never know until you actually throw the Hail Mary. And then so in this environment, creativity, persistence, it makes all the difference. And it's a lot of times we get so obsessed about finding that single silver bullet. It's not necessarily about that. It's about layering, the legal, procedural, and humanitarian arguments to get that going.
Agreed. And I think it's also important to know your landscape, know your local field office, know the policies that are in place at the field offices, at the local courts. Rules change, not just by court, also by judge. So even though things might look uniform on paper, it's really important to know what differences are in practice from one jurisdiction to another. And make sure that, obviously something that might work in the Ninth Circuit in California might not work in the Fifth Circuit here in Texas. So knowing what things to do where is also going to help you with those efforts.
Exactly. Knowing local ICE leadership and their tendencies can definitely give you a lot of insight into which arguments can resonate with them.
I agree. Even in this climate, it's still important to know that strategy and persistent, they matter, right? So we have seen that mandatory detention for EWIs, it's expanding, but it's important to remember that so are the tools to fight it. So the key is precision. It's to challenge DHS's authority, use that parole strategically whenever you think that it's going to work, and never underestimate the power of coordinated advocacy. What we're doing now, talking and sharing strategies, sharing what we can do. So it's important for anyone watching, if your loved one has recently entered without inspection many, many years ago, or it just is undocumented, follow us for continuing updates. If you need help, if your loved one is detained, you can reach out to one of our offices for help so we can keep fighting for freedom one case at a time. And if you found this discussion helpful, don't forget to like this video, subscribe to our channel, and leave a comment if you have any questions about immigration law. We'd love to hear from you.